This is Module 2 of the use of public dollars, public bid law, and professional services contracts. I'm Angela Heath, again, one of the attorneys here, and Patrick Fergadamo is the other attorney who will be joining you in the later modules. So this module, we're going to cover the public bid law. The public bid law was enacted to in the interest of taxpayers, to protect them against contracts of public officials that were entered into because of favoritism or with exorbitant prices. So the thing to remember with the public bid law is you want to have arm's length transactions. You want to make sure people are not getting favors from each other. They're not giving it to their, their good buddy, their friend, and there are no $500 hammers. Only the federal government is allowed to enter into contracts for $500 hammers, okay? Now, the public bid law, another thing to keep in mind, besides arm's length transactions, what you want to keep in mind is it is a prohibitory law. What that means is that a public entity has no authority to take action that is inconsistent with the public bid law. The third thing I want to keep in mind, for you all to keep in mind, public bid law is not a negotiation, okay? What you want to think about is public bid law is like following a recipe, but a baking recipe. I have a mother who's a very good cook. She kind of the whole kitchen looks like a whole mess afterwards. I don't think she even really knows what she puts in, but she kind of tastes a little bit as she goes. She adds a little more of this, a little more of that. You ask her how she made this. She can't tell you. She says, well, I put, like, how much salt do you put in? As much as you need. That's literally an answer she will give you. I'm not like that now, but my mother is not a good baker because she can't follow the recipe to the letter. I am a good baker, actually, because I can follow a recipe to the letter. And as you know, if you are a baker, if you don't follow the recipe to the letter, the cake's not going to rise, right? So with the public bid law, it is like baking. You have to be precise. You have to follow the steps of the public bid law to the T. So keep those three things in mind as we are going to talk about here in this module, the public bid law, exceptions to the bid law, and professional services. Now, the public bid law and the exceptions are in Title 38. As I told you, Patrick will be covering the module for the Louisiana Procurement Code, which is Title 39. He will also be covering the federal standards, which is for procurement, which is 2 CFR 200. Focus of these modules are really for you to know what rules apply to which situations. And the purpose of these laws, as I said, is to be transparent and accountable to the public. Article 7, Section 14 of the Louisiana Constitution comes in play. Here's the actual text of it. Comes in play whenever you're talking about public funds. And what that constitutional article says is when you use the public funds, this is the standard you use. And it has to be, what you have to keep in mind is these are from $1. The responsibility of a public entity starts with Article 7, Section 14. If you're spending $1, because it's public money, it's public property, it's public time, it's public employees. Now, there are two types of public contracts covered under the public bid law. They are the materials and supplies and public works. Services is not covered under the public bid law. It is exempt from the public bid law. We will talk about how you handle services. Now, that's different, keep in mind also, though, from the Louisiana Procurement Code, and it's different from the federal regulations. Services are under those two types of public contracts, the rules for those types of public contracts. Now, let's start with materials and supplies. Whenever a public entity is purchasing materials and supplies exceeding the sum of $60,000 or desires to construct or alter a public work, such as a building, for the sum of $250,000, there must be a public bid process, which will give them, which they have to follow as set out in the public bid law. These limits were just raised in 2020. They raised the public works limits to 250,000, and in 2023 they raised the material and supplies limit to 60,000. Now, materials and supplies are not defined in the statute. It actually says materials and supplies are materials and supplies. That literally is in the definition of the statute. But it's commonly understood in this context to mean movable property that's necessary to conduct the public entity's business. So if you can pick something up and move it across the room without having to do any types of construction, it is materials and supplies. It also will include equipment. Printers, vehicles are also included in materials and supply. Heavy equipment, tractors, things like that would all be under the materials and supplies portion of the public bid law. Now, some things to keep in mind. If what you're buying is less than $30,000, the prudent person rule is what standard applies. Article 7, Section 14 still applies in all of these situations. You still have to be good stewards of the public money. You need to get a reasonable return on the value for whatever the public funds you're spending are. So, but technically, you don't even have to get quotes. But we recommend that you do get quotes. We recommend you at least shop around to make sure you are complying with Article 7, Section 14. Between $30,000 and $60,000, you are mandated to get 3 documented quotes. And that can be, the law says fax. I don't know how many people are using fax anymore, but they can be telephone, but document your file, what that person that you called said they could sell you that, that piece of equipment for. Email or a printable electronic forms. Now, I say that means that you can go on a vendor's website and print out what he's selling and document that in your file, and that could be a quote. There is not an actual attorney general opinion on this, so this is just something that we think, though, when you're reading the statute, would apply. But the important thing here is to make sure you document your file that you obtained at least 3 quotes before you went out and bought whatever that item was. Now, if it's between $30,000 and $60,000, a question we get quite often, do you have to take the lowest one? You don't technically have to take the lowest one because it is under the $60,000. The requirement to take the lowest comes when you have to go out to bid. But if you don't take the lowest, you should have documented reason why. I had someone who called in and they needed to get a little refrigerator unit. And one person could have it delivered by the end of the week. The other person that was actually a little bit cheaper, it was under $60,000, was going to take, it was like a 2-week delivery or a longer delivery time. So he said, could I get the one that's like $500 more? Because I really need it now. And, the sooner the better. And I can have that one by the end of the week. I said, document your file. That seems to be a reasonable reason why you would accept the one that was a little bit higher, because it still was under the 60,000. That's the important thing to note. It was not actually going out for bid. It was the quotes. Now, once you get to the 60,000 limit, though, you have to go out for bid. And that is when all those rules that I'm talking about, the recipe applies. You have to do it. You have to advertise 2 times on the timelines that are in the statute. You have to have electronic bid if you are capable. You have to, one of those advertisements, like I said, has to be at least 15 days before the opening of the bids. You have to open the bids, or you can cancel all the bids. But if you're not going to cancel, you have to accept the lowest bid. Now, the requirements for letting the contract out. Now, what if you open all the amount you have to have reasonably estimated before you go out for bid what this item is going to cost you. So the thing is more than $60,000. You have to have a reasonable estimate of what it's going to cost, and you have to have that money allocated before you go out to bid. If you get all the bids in and all of them come out way more than what you've estimated, then that's a good reason to cancel all the bids and start over. And maybe go back and look and why your estimate was off, because you cannot accept the bid if you don't have the money appropriated. You have to make sure with all these advertising requirements that you plan ahead, count your days, get your calendar out to know this is when the bid opening is going to be, how many days back, when's 15 days, because the official journal needs some lead time before they can get it printed 15 days ahead. So you have to go back maybe a week before that to make sure that second advertisement is at least 15 days before the bid. So you have to plan. You have to plan how you're going to receive the bids. Are you going to do electronic bids? Are you going to do a mix where you take both, written bids delivered to you and electronic bids? You have to make that choice. Once you have accepted the bid, you have to have a contract. The contract should reflect what you actually bid on. So you have to form that contract and you have to monitor. Make sure you are actually getting what you paid for. Now, when you open the bid, the lowest bidder is the person who is the lowest responsible bidder. The law does not really define what responsible means, but what happens, someone who's not responsible could be someone that you have information or belief that they would not really be fulfilling this contract. Maybe you've dealt with this person in the past and they have given you shoddy goods, not what they have promised. You have to have a good reason to think this person's not responsible. But what can you do if, in fact, who appears to be the lowest bidder is not responsible? Well, you have to give them due process. You can reject them, disqualify them, but you do have to do a formal process where you give written notice to the potential bidder, and you have to actually give them a hearing, an opportunity to be heard at an informal hearing to respond to you and say, no, I've changed my ways. Yes, I used to have companies and then I would like file bankruptcy and then immediately start another company and then file bankruptcy. But I've changed my ways. I've seen the light. After that informal hearing, if you do still disqualify them, you have to have some lead time for them to go to court to object to your disqualification before you actually award the bid to who is actually the lowest bidder, the second lowest bidder, but who is the actual lowest bidder who is responsible. And these are the actual timelines. It has to be no later than 5 days after the date of the notice. The hearing has to take place. You have to deliver in writing your ruling no later than 5 days after that informal hearing. And you have to wait 5 days to give that person that you've disqualified the time to go to court to seek injunction before you award that bid to the new lowest bidder, the lowest responsible bidder. That's why disqualifying a bidder should be taken seriously, and when you really have good reason to disqualify the person. It's not just because you don't like them, right? You have a good reason to know that they should be disqualified. So let's talk about some examples. Say your city and you use on average $6,000 worth of paper per month. Do you have to bid this out? Well, yes, you do have to bid this out because the rule in the public bid law is that you are supposed to estimate. These are kind of consumable purchases or recurring purchases. You can't just say, well, look, I only use $6,000 worth of paper a month. The limit is 60,000. I can just go every month and buy whatever paper I need. The public bid law says you are supposed to, for these types of recurring purchases, estimate how much you use in a fiscal year. How do you get a reasonable estimate? Well, you look at how much you spent last year and maybe the year before that, and you can see how much you were spending in the last 2 years, and that's your reasonable estimate. So 60,000 times 12 is going to be 60 plus another $72,000, right? So that's definitely over the $60,000 limit. You have to bid it out. This is what you call a requirements contract. You will bid it out. The vendor that's the lowest bid, you accept his bid. And what you do is you're not obligated to actually spend that amount in that year on that contract, but just as you need it, you're going to issue a PO, a purchase order, and that vendor will supply it on. So you're buying it monthly, but you've got the year contract in place with the unit price for how much each time you buy that paper, it's going to cost you, that ream of paper. And really, you would be doing all, not just paper's in the example. You would put like items like this together. Like you would do all of your office supplies, paper, pens, paper clips, folders, all those types of like items that you would be buying from a similar vendor and bidding it out. If it's over $60,000 in a year that you're spending, bid it out and have that, the bidders give you unit prices for each of the items. If you don't do that, if you did just go month to month and just buy what you wanted, that would be what's called splitting to avoid the public bid. And that is not allowed under the public bid law. Now, let's look at another example. So a fire department has hired a new fireman and they need that, they don't have a respirator for him. The cost is $8,000. Judging from the condition of the respirators on hand for the other firemen, the chief can see that 7, while still in working condition, will probably need to be replaced before the end of the fiscal year. The total for all 8 respirators would be $64,000. Can the department buy each respirator when the need arises, or should they bid them out altogether? Now, if you were just dealing with the one, you could probably just go out and buy that one. But knowing that you're going to need 8 within the same fiscal year, you should bid that out. If the answer would be different, like I said, if the respirators, the rest of them are great and you're not going to need them for the next fiscal year before you buy the other 7, replace the other 7, then that answer could be different. But something else I want to point out, this type of equipment can be purchased also, might be considered a recurring type of purchase. And you could not just bid it out with the same way you would do your office supplies on a requirements contract. You can also do these types of contracts for multi-years. Like you can have a 2 or 3 year contract for your office supplies or for this type of equipment that wears down after time for the firemen. Okay, so another example to discuss with you all. The police department needs fuel for patrol truck vehicles. Gas prices are always fluctuating, but one tank costs about $60, and the department easily spends more than $60,000 a year. Can they purchase gas as needed, or can they bid them out? The Attorney General has said for these types of, for purchases like fuel that has volatile fluctuations in price, you bid them out on a price index. And the way you can award to the lowest quote responsible bidder is you consider the discounts to determine the competitiveness, and that's how you award these on price indexes. Okay, so now the police chief needs to purchase new cameras for the police department. The cameras have to be compatible with Nikon brand currently being used. The Nikon representative says he is the sole source for the compatible cameras. I'm bringing this up because everybody always wants to say they are the sole source. Can the police chief purchase the cameras from the Nikon representative as the sole source? Well, 2 things I want to point out to you. The public bid law does not have any requirements for sole source. That is the Louisiana Procurement Code. The Louisiana Procurement Code applies to state agencies. The public bid law applies to local political subdivisions unless that political subdivision has adopted the procurement code. So generally, under the public bid law, you can't do sole source. But also, in today's day and age, there's very rarely a true sole source. So I would say you cannot do a sole source. What you can do, though, is you can go out to bid and you can say, I want this type of camera, that I want a camera that is compatible with this Nikon that I already have. You have all the specs written out that are the Nikon, but you put or an equivalent alternative that must be on there. You cannot limit your bid to only Nikons. It has to be something, but you can put in your specs and make sure your specs are written properly to where the cameras that are going to be bid, that the bidders are going to submit, will be compatible with the system that you already have. Now, on the Louisiana Legislative Auditor's website, under our FAQs, we have what we call Public Bid Law FAQ, and we have what we call the Public Bid Law flow charts. And this is the flow chart that is on, that you can find on the website, that goes through all the steps for purchasing material and supplies under the Public Bid Law. We have here, as you can see, our recommendations for when it's less than $30,000, but then the mandatory requirements from 30 to 60, and how, when it exceeds 60, how you go out to bid, the advertisements that you need to have, the days that they have to be in there, and then how you award the bid, and how to reject the bid. So that's a nice little handy flow chart to have to understand how to purchase materials and supplies. Now, the second part of the public bid law is the public works. Public works is building and renovation. For a public work, $250,000 or under, the prudent business person standard applies. You may utilize your own employees, but if you are going to utilize your own employees, you still have to bid out the materials and supplies. But important to remember, when you're coming to your reasonable estimate of how much this project is going to cost, you include the labor cost and the materials and supplies to get the total of how much it's going to cost. So that's in your calculation when you make your estimate to know whether the public bid law, whether you have to go out to bid or not. Now, again, remember, this is public works. Public works is anything that's permanently affixed to the building or to the land. So people, an HVAC system, when you're replacing an HVAC, so you can say, well, that's movable because you bring it there, but you have to like go into the walls for the vents. You have to actually take out walls or do construction to attach that HVAC system to the building. To me, would be a public work. Now, that's my opinion, okay? That's my opinion. You know, attorneys, we can have different opinions on things, but I would think if it's permanently affixed and it takes real construction to unattach it, it becomes permanently attached to the building. But other things like light fixtures, for example, might not be a public work, okay? Because it's easily taken down with just a couple of screws. Now, we suggest if it is under the $250,000 that you still like your reasonable, you do your reasonable estimate. It's, you know, $200,000. So yes, you don't have to go out for public bid. You could use your own employees, even bid out the materials and supplies. We still think you should get at least 3 quotes. You can't just go out and hire the contract that you like, that you know does a good job when it's under the $250,000. But still, again, we suggest you get three quotes just to make sure you're complying with Article 7, Section 14 of the Louisiana Constitution. Okay, so what do you have to do if it's more than $250,000? You have got to advertise. Again, you have to follow the recipe completely. Make sure you get everything correct. Advertise 3 times. The first advertisement has to appear 25 days before the opening of the bids, and it cannot be on a Saturday, Sunday, or legal holiday. So again, you're going to have to get your calendars out. You're going to have to count your days. And remember, your newspapers are going to need some time before they actually get it published on that date that you want it published. And you cannot change the bids within 72 hours before opening, but you can extend opening 1 week if there is an emergency. Now, a preliminary step. Do you have the money to go out, and what is a reasonable estimate? You have got to make sure you calculate this, because you cannot let out a public bid if you do not have the money appropriated for the job. You have to, like I said, you have to make sure you advertise your bids, make sure you get your counting straight, how you're going to receive and open the bids, electronic bidding, in-person bidding. Selection now of the lowest responsive and responsible bidder. This is different, right? Before we had responsible only. Under materials and supply, the law says you select the lowest responsible bidder. Now you've got the lowest responsive and responsible. Responsive bidder means the person who meets the requirements that are set out in the advertising bid documents. In public works projects, they have some very specific requirements and specific forms that have got to be used. If a person responds to you and does not, for example, put his contractor's license on the envelope as required under the public bid law, you cannot take that person's bid. Doesn't matter what a great price he's giving you. You've got to follow it to the T. So that is what a responsive bidder means, that he has responded appropriately. There is an attorney general opinion where the instructions said that don't leave any blanks. So some things the person should have put a 0 on the line for that item. He did not. He left it blank. That was rejected as being non-responsive. Okay, so that's how strict they are on this. Now, responsible bidder would be the same, just like under materials and supplies. This is a shady person, you've dealt with him before maybe, or the town next to you has. He didn't fulfill the job. He walked off the job. He used shoddy materials, something like that. And that is going to require the same type of due process hearing that you would have had, that you would have to disqualify a bidder under the materials and supplies that we've gone over. Contract formation, very important here. The contract formation should be easy because it should be a complete reflection of your bid specs and your bid documents. But you've got to make sure you have the contract executed and that you monitor the work to make sure you are getting what you paid for. Now, here again are just the slides again with the due process to disqualify a bidder who is not responsible or responsive. You still have to give them the due process. You still have to give them the notice, the informal hearing, things in writing, and the opportunity to go to court before you award the contract to the true lowest responsible and responsive bidder. Now, here are some I can tell you want to be very careful with who you select on your lowest and who is the lowest bidder, because the person who's going to know if that person was responsive is going to be the second lowest bidder, and that person can cause trouble for you too. So you don't want to try to waive something. Okay, well, he didn't really put his contractor's license on the envelope, but the price is so good, I'm going to give it to him anyway. The second lowest bidder can cause trouble for you too, because he's going to say, I was the true low bidder. So you want to be very careful on how you handling the awarding of the bid. Now, there are some timelines as well on how you have to award the bid. You have to award the contract no later than 45 days from the bid opening. Okay. However, the lowest responsible and responsive bidder can agree to extend that deadline by 30 days. Now, the contract formation, the public entity and the awarded bidder, you have to execute the contract no later than 60 calendar days from the award of the contract, barring any injunction that may have happened because of the disqualifying a bidder. Now, similar to materials and supplies, you cannot split jobs. You cannot say, well, I have to do this renovation, the roof is going to cost a certain amount, the rest of the building is going to cost a certain amount. Together they add up to $250, but if I just did the roof, it's not. And if I wait a couple months and do the rest of the building, I can split it up. No, that is not allowed under the public bid law. You cannot do out-of-hand disqualifications. So you cannot prevent someone from bidding from you you cannot pre-disqualify people from giving them the opportunity to bid. What you can do is you can have, as part of your public bid process, a mandatory bidders meeting, and that if they don't attend that meeting where you take questions and everything on this after the specs are out, that they can't bid. That's something that you could do. When you're drafting the contract, you have to follow your bid specs. Change orders. So project gets started and something has to change because maybe they start digging and they find a bigger issue than what had originally been put out in the bid specs. That can be done within the scope of the contract, and we're going to talk about that more. And you may require recording that change order with the Register of Mortgages. You want to make sure everything in your contract, your bid specs are precise so that you're getting exactly what you want bidded. And you have to make sure you monitor what is actually going on to make sure that you're getting what you've paid for. Now, as I've discussed, it is mandatory to use standard bid forms provided by the Division of Administration for Public Works, and there is a link on that slide of where those forms can be found. We talk about change order. Any contract modification that includes an alteration, deviation, addition, or omission to the pre-existing public work contract that would cause an adjustment in the price, the time, or any type of revision of work is what you call a change order. And the important thing to remember with the change order is whether it's within the scope of the contract or not. If it is, like I said before, they start digging in the ground where the building is going to go, and there's some issue that they're going to have to maybe do some blasting or something like that. There's rocks. That's a change order within the scope of the contract because it was something that wasn't foreseen and it has to be done in order to build the building where it was supposed to be. If you've decided that he's doing a really good job so far and we didn't have a garage, a public parking garage, and we really should have a public parking garage for this city hall that we're building. Let's just say that's the project. So let's just go ahead and hire him to do that. That's not a change order. That's a complete addition. That's outside the scope of the public of the contract. If it is, you had a public works contract to repair streets, and there were and the person is doing a good job repairing the streets, and you want to hire him to do some more to extend it, to do additional work than what was originally in that bid. That's going to depend what was in the original specs for that. If it was just generally to repair streets in the municipality, that might be a change order. But if it was, the original contract was limited to like a specific geographical area, you could definitely be a change order to add more streets in that geographical area, but you could not add it to, like, say it was in the south side of town, now you want them to do it on the north side of town. That would not be a change order. So sometimes what a change order is, you got to really look at your specs and what was in the contract to determine whether it was a change order or not. Okay. And that's basically the definitions here. Outside the scope means something that was not really part or integral to the contract. Within the scope would be something that was an integral part of the project. Now, there are some recordation requirements with change orders. If a change order adds 10% or more to the original contract price, and it's at least $10,000, or if you have several little change orders that are an amount of 20% of the original contract, and it's at least $10,000, you have to go record those change orders. The public entity must record those change orders in the Office of the Recorder of Mortgages in the parish where the work is being done. Now, if you have to change those, record because of those change orders, if the original contract itself was not recorded, you're going to have to also record that original contract as well with the Recorder of Mortgages. Now, rejection of bids. For materials and supplies, there is no definition, but there is a definition under public works in the public bid law. And so we can kind of use them. Some of them don't apply, but this is what the law defines as rejecting all bids. So all the bids come in and you want to reject all of them. You can reject them for just cause. Just cause would be, one would be insufficient funds. You bid out the project, you thought it was going to cost $300,000. You've got your reasonable estimate. You have $300,000 to spend. All the bids come in over the amount that you've appropriated. That is just cause to cancel all of the bids, reject all the bids. And honestly, if that happens, you need to go back, the public entity, and see what was wrong with our reasonable estimate. What did we do wrong when we came our reasonable estimate? Now, if it's close, you might not need to do that. But if you estimated $300,000 and the lowest bid comes in at $400,000, there might be something wrong with your process. Yes, reject all the bids, but then revisit your estimate and how your estimate was off so much. Now, the failure of any bidder to submit a bid within the established threshold or in accord with the bid specs is just cause to reject all of the bids. A substantial change by the entity to the award within the scope and design of the proposed work is a reason. So the thing with the parking garage, before you open the bids, the public entity decides, you know what, we're building the city hall. We really need a parking garage as well for this. That would be a just cause to cancel, to reject all the bids. A determination by the public entity not to build the proposed public work project within that same within 12 months of the date of the opening of bids would be a just cause to cancel all the bids. And if you disqualify all the bidders, everybody who bids gets disqualified, then that's a reason to reject all of the bids. So that's rejection for just cause. Now, these are some Attorney General's opinion regarding rejecting the non-responsive or non-responsible bidder. So you public entity may reject bids as non-responsive when the low bidder fails to comply, or the apparent low bidder is really what it says here, to comply with the bid documents and instructions which require all the blank spaces to be filled in to provide a price or an alternative. What that person in that case should have done, because he just left it blank, he should have put a 0 with a line through it. He could have put NA on there. So then he would not have been non-responsive. Now, in another Attorney General opinion, the Attorney General said that the a parish may reject a bidder or potential bidder for lack of responsibility or responsiveness, but cannot debar a bidder to automatically disqualify them from ever submitting a bid. Another Attorney General opinion on this is a bidder's inclusion of an annotation on the bid form that the price was subject to a 3.5 escalation per year, when the bid documents clearly indicated that the bidders that the prices had to be definitive and remain unchanged during the length of the contract, was a non-responsive bidder. Now listen, you can put in price escalation clauses. Earlier when we were talking about materials and supplies, doing a multi-year contract for, say, all your office supplies, that could include, if you allowed it as the public entity when you're going out for bid, for an escalation for year 2 and year 3 for prices to go up. You could include that, but you have to have that in your bid specs, public entity, and you have to allow for that. The bidder responding, putting his own escalation clause would be non-responsive. Like I told you from the beginning, public bid is not a negotiation, right? The public entity is in charge of making sure that their specs are very clear and that they're going to get what they want. They do not negotiate with the bidder after the fact. The bidder has to meet the specs or not. And if he does not, he's non-responsive. There is a lot of stories, especially with COVID, the price of steel went up a lot, price of lumber went up a lot. We got a lot of calls in that said, we awarded this public works contract prior to COVID. Now my contractor who's already started the job has come back to me and says, hey, the price of steel has gone up, or the price of lumber's got up. I've got to adjust my price of what you accepted in the contract for this public works. That person is out of luck. He has got to deliver that building to you, or whatever that project is, to you for the price that he was awarded to do it. If he does not, that is why you need to have a good default clause and penalties in your contract for non-delivery. There was a story about a pier that was being dug. I can't remember what port it was, but it was multi-million dollars. And the company that got awarded the contract went bankrupt, could not finish the job. The bond bank had to step in and had to finish that job. That's why bonds are required. Performance bonds are required, for example. That's why you need to have a good default clauses in your contracts when you do these public works contracts. But no, you cannot just agree after the fact, if there's not an escalation clause, to, okay, we'll pay you more on this contract that you were already awarded because COVID happened and the price of steel went up. That's not allowed. Okay. Now, design build is only allowed in Louisiana when it's authorized by law. Generally, design build is not allowed, but this is a good Attorney General's opinion that discusses design build. Now, you cannot add requirements to your public bids that are not allowed in law. Remember, again, I told you the public bid law is a prohibitory law. You have to follow it exactly. In this case, the city of New Orleans had added a local hiring preference to their public works contracts. They could only hire local workers. The contractors had to hire local workers. They could only be located in New Orleans, etc. And the Attorney General said that is not an inclusion of, there was no legal authority, if absent any legal authority to establish a local hiring preference, the public entity could not do that. Requiring the contractor to only hire local people who lived within the city, was also impermissible under the Louisiana public bid law because there was no authority in the public bid law. You have to follow it to the T. You cannot add these other things without the authority to do that. Uniform bids, you have to use the uniform bid form. That is mandatory. You cannot waive it, the public entity, and the public entity must reject any bids that are submitted not using the uniform bid form. So let's talk about some little scenarios with public works. So a school district needs to replace the roof of all 10 of the school buildings in the district. The cost of each building to replacing the roof would be $30,000. Can the school do these as separate projects, or must they bid it all out as one $300,000 public work project? Well, I kind of think, and we would say that if you know you have to do all 10, you should treat this as one project, not 10 separate projects. And otherwise, you would look like you're trying to split it up to avoid the public bid law. Because, right, if it's under $250,000, you can just go hire whatever contractor you want. So we would say you should bid it out for the $300,000 as one project. Now, what if the district only had, now remember, you got to do your reasonable estimate. It's going to be $30,000. All 10 schools, $300,000. We don't have the money, $300,000, to do all of those roofs this year. We only have the money to do half of those roofs. And then we can put the other half next year. You know, do 5 this year, $150,000. Do 5 next year, $150,000. The Attorney General has actually said, when there is a real economic reason for doing the project in phases. Phase 1 would be the 5 this year. Phase 2 would be 5 next year. Then it is not splitting. It is not impermissible splitting. So you could go ahead and do the 150,000, 5 now this year and 5 next year without violating the public bid law. Now, I will point out, you could bid it out in phases, and you could put that in your specs that you want half done this year and half done next year. That would be a way to make sure you're safe. No one could accuse you of trying to avoid the public bid law. But if you are going to do it for fiscal reasons, and not go out for bid, because you're only going to do 5 this year, make sure you document your file as to why that decision was made. That is something that an auditor might be looking at, of why, what was your thinking and rationale behind this decision of doing only 5 now. So if you have a legitimate reason, it would not be impermissible splitting. Now, a parish properly out for bid street repair project, and the winning contractor is doing an excellent job. The parish would like to do a change order to add more streets to be repaired by this contractor. I think I kind of already talked about this, but this answer is, it depends on what the bid documents, the specs actually say, what the contract actually says. If it was a geographical area limited, then if the additional streets were also in that same geographical area, then I think it would be a change order that you could add more streets to it. If it was streets in a different geographical area, then it would not be a change order. Or if it was written very broadly and it was just streets within the municipality, then it could be a change order. That's allowable change order. So, city wants to do major renovations at City Hall. The cost of all the repairs will come in under $250,000. Can the city use its own workers to do the renovations? Yes, they can. If the reasonable estimate is less than $250,000, they can certainly do their own workers, but and remember, the estimate includes the cost of the labor. And that's something that to keep in mind, as if you're a public entity, using your own workers, there are some hidden costs in there. Think about it. Workers' comp, not doing what their usual duties. We would still recommend that you get a contractor for that. Get some quotes and get a contractor for that job, because there are hidden costs that you don't consider, especially if you're taking those workers off of their regular jobs and putting them on this job now. And there also might be additional expenses with workers' comp. So what can you choose to bid the project out even though it is under the threshold? Yes, you can always do more. The public bid law is the minimum. If you had, even with materials and supplies, if you know something is $40,000, you only need quotes. Could you go ahead and bid it out anyway? Yes, you can. And same thing with public works project. We're doing this building renovation, major renovation. Can we, and it's $200,000. Could we go ahead and bid it out? Yes, you can. Remember, but once you start using the public bid law, all the advertising requirements, selection of the lowest responsible and responsive bidder, all of those things will apply. So you can always go out to bid for lower than the threshold, but the threshold is the minimum that you must go out to bid. Just like with the materials and supplies, we also have available on the LLA's website a public bid law flow chart. As you can see, it's much more complicated because we've got stuff you got to do for $250,000 or less. We've got the whole thing on the disqualification, the due process hearing that you have to have for the disqualification is on here. And it's a lot more complex, but it's maybe a little bit more difficult to read on the screen here for you, but when you print it up, you can, I think it's easy to read. Like, we've got all the reasons you can reject the bids for just cause. The requirements for the change orders are on here, within the scope, without the scope, outside the scope. I don't know if you can see it on your screen, but down there in the corner, it's got the date. We update these flow charts and the FAQs every year after the session. We try to get them published by August 1st, because August 1st is usually, not always, the effective date for the new laws to kick in after session ends. Session ends in the spring, before summer in a calendar year, and the new laws usually become effective August 1st of that year. So we do try to have them up, but usually we're not later than mid-August. And but always look there at the corner, and then you can see it's the most updated one. So this is a very helpful chart for you can print it up, have it at your desk, and to refer to it easily anytime you want, okay? Now we're going to talk about the exceptions to the public bid law. Now, first, we're going to talk about emergency exceptions. There's an emergency and there's extreme public emergency. During these times, you do not basically have to follow the public bid law because, hurricanes come, torn off the roof, water is coming into the hospital. You've got to spend the money to cover that roof, right? You've got to get that tarp. You do not have to wait to go out for bid on that tarp, even though those tarps are very expensive. And that would be a material and supply, right? And that tarp, though, was like $100,000. Well, you've got to stop mitigating the damages, especially if you have insurance. Your insurance company is going to require that you have tried to mitigate the damage. And like I said, public health safety, water's coming into the hospital. You need to get that. You don't have time to follow the public bid law. For a regular emergency, you do have to have a certification of emergency and notice within 10 days. And then you publish that in the official journal. So in extreme emergency, you have a declaration of publication within 10 days or as soon as practicable. Okay. What you want to make sure you do, if you're the entity, is you want to make sure you are documenting what you contracted for, what you bought, how much the cost was, right? So whether it's an emergency or extreme emergency, you want to make sure you are documenting what you bought. Did you call to get quotes? Could you even call to get quotes? Was there one person that even picked up the phone for that tarp to cover the roof for the building when the water was coming in? That's what you want to document. The contract, verbal contract, right? That you had the guy come in, you should try if you can get it in writing, make sure you get it in writing. Could be a case where you've got an invoice and you've got a check, right? So these are the actual definitions in the law. An emergency would just be an unforeseen mischance bringing with it destruction or injury or of life or property or immediate threat of the destruction. It also could record a court order. But let me tell you something an emergency isn't. An emergency isn't that you procrastinated and you did not order the stuff, go out to bid soon enough. You knew the thing was coming up and you had to take care of it. That's not an emergency, okay? An extreme emergency is usually it's going to be a catastrophic event. A hurricane coming through is going to be an extreme emergency, and you cannot obtain a quorum of the members of whatever the governing authority is to certify the emergency prior to declaring it, okay? The water coming in through the roof, that is definitely an extreme emergency. This is an Attorney General opinion that goes through the statutory mandated processes for declaring a public emergency and engaging in emergency procurement under the public bid law. Now, there are other exceptions or alternatives to public bid that public entities are allowed to use. These are all of them, and we're going to go through each one of them. So I'm not going to read them here on this slide. We'll go through them as we go through the slides. One thing that we're not covering here, there is group purchasing that is allowed for 3 types of public entities: hospitals, schools, and now new law in 2024, public safety entities, municipal police departments, fire departments, EMS. These are the only times you can buy from a group purchasing organization. They have got special rules for them of what is a qualified group purchasing organization. And it's only, again, hospitals, school districts, and now after 2024, the public safety entities, municipal police departments, fire departments, EMS can participate can purchase items as an alternative to the public bid law from group purchasing organizations. So now let's go through some of the alternatives to the public bid law. Purchasing surplus property from another public entity. This statute here that's on your screen authorizes political subdivisions of the state of Louisiana, okay, to sell its surplus property to another political subdivision of the state of Louisiana. I'm pointing that out is because you can't buy it from the Texas city that has surplus vehicles. It's got to be another Louisiana. It's only Louisiana to Louisiana. Okay. You can buy surplus property, public entities in Louisiana from one another without a public auction or public bid process. I'm saying public auction because surplus, when a public entity declares property surplus property, they no longer need it. There are certain rules that they have to declare it surplus and how they have to sell it. They have to get fair market value and some other rules in there. Now, this, you must use a cooperative endeavor agreement, which we talked about in module 1, to do this transaction. And it must, the public entity that's selling must still receive fair market value for that surplus property. It could be money or services. So this is not the same as the lending of the equipment that's allowed in the Louisiana Constitution. This is actually transferring public property, surplus property from one public entity to another. So, use common sense on how to do this, but it is allowed from one public entity to another. And you don't have to go through the bid process or the public or the regular surplus auction process to sell the property. Now, there is an exception to the public bid for the purchase of used fire trucks. It's up to $100,000 you can buy. There's a process to buy used fire trucks. Now, there is also a new law in the for police and fire vehicles up to $70,000. They do not have to go out to bid for purchasing of police and fire vehicles, or that are going to be used for police or fire, up to $70,000. Their threshold, remember we talked about the materials and supplies, that the threshold was up to $60,000. Once it was 60, you had to go out to bid. For police or fire vehicles, it's up to $70,000 before they have to go out to bid. Now, this is obviously different. You're never going to get a fire truck for under $70,000, a new one at least, but you can buy a used one following these statutes of up to $100,000. Piggybacking. Piggybacking is, there's two different ways you can piggyback. What piggybacking is that another entity has just let out a contract, they awarded a contract, and you want that exact same thing that they just bought, that tractor that they just bought. There's two ways you can do it. You can do it under the local services laws, or you can do it under revised statute 321.1. And so I call it, the local services law method of piggybacking was developed over the course of different attorney general's opinion. So I call it the attorney general way of piggybacking, or I call it the statutory way of piggybacking. But technically the local services laws have statutes too, but that's just how I refer to them. Now, the attorney general way, the local services law way, they're very similar. In both cases, you have to get, so you're a city and the city right next to you bought a tractor that you really want. They let it out for bid. They bought this tractor. You want the same tractor. Both the local services way, the AG way, and the statutory way require you to get certification from that other entity that they follow the public bid law properly. Okay. Both of them require that the vendor that sold them the tractor agrees to sell you that tractor. They have to be the exact same materials and supplies. Now, exact same. Maybe their tractor was white and the vendor says, yeah, I can sell to you, but I'll sell to you at the same price, but I've only got a blue one. I mean, the color, if all the specs though are the same of what that thing is going to do, that's going to be okay. It's only for materials and supplies. You cannot, there's actually an attorney general opinion, you cannot piggyback off of a public works contract. It can only be for a materials and supply contract. Now we start getting some little bit of differences. Under the AGOA, the time that you can have before you can piggyback. It says the original contract is still active, fresh, or viable. The statutory way is 1 year from the opening of the bids. So what does it mean under the Attorney General way that the contract is still active, fresh, or viable? I would say, although there's not an Attorney General opinion, I don't think that makes it clear. I think that a contract is still viable if they have not actually accepted delivery yet. Once, if you bought that tractor and that vendor has delivered that tractor, I think that's the contract is over at that point. That's my opinion on that. So, but if it was, say, a requirements contract, maybe you want to piggyback off of an office supply contract that a city has, that is a multi-year contract, then that contract would still be open, fresh, and viable. And that would come in play if it is 1 year after the opening of that bid for that requirements contract, then you definitely want to use the local services way to do it. If it's been the tractor and it's been delivered, then you definitely want to use the statutory method. Now, the amount, there's no limit to how many of that thing under the local AG way. You can buy 3 tractors, the 3 of the exact same tractors at that same price, that even though that other city only bought 1. The statutory way only lets you have 2 times the purchase of the original contract. So if the city that bought the tractor that you want to piggyback off of, you can buy up to 2 tractors under the piggybacking method. The price has got into the Attorney General way has got to be the same or lower. Under the statutory way, it's got to be the same price. And who can use it? The Attorney General way, because it's based on the local services law, only local entities can use it. The statutory method can be the state or local entities. State entities or local entities can use that one. So that is a factor in who's going to, which method you can use. Locals, governments can use both methods. State entities can only use the statutory method. Okay. And I think I'm going to point out here, even though Patrick is going to talk about it with you further, but I just want to point out when he talks about the FEMA procurement requirements, using piggybacking may be something that you want to check. If you're using federal funds, you want to make sure before you use piggybacking method to buy something, if federal funds are involved, to get something in writing from your funding agency that it would be acceptable to use the piggybacking, because it's not quite clear whether it would violate the federal open competitiveness requirements. So just not without any other information, I would say if you're using federal dollars, you should avoid the piggybacking method. Okay. All right. Now, here are some Attorney General's opinions discussing the piggybacking. And it's basically saying that local governmental entities, parishes, municipalities, political subdivisions can use either the local services or the Attorney General method or the statutory method for piggybacking. And then it also has what we've already gone over, you know, the statutory way within 1 year of bidding, the previously bid contract, same price, no more than 2 times, and the Attorney General requirements of a viable contract at the same or lower price. You cannot piggyback off of a contract that's some type of national cooperative purchasing contract that has not been competitively bid by another Louisiana public entity. Like I said, it's got to be Louisiana to Louisiana. And Louisiana municipality cannot make a direct purchase from the NJPA, which is a national contract, unless the Office of State Procurement has adopted that as a state contract. We'll talk about purchasing off of a state contract. And like I told you, it only applies to materials and supplies contracts, which includes equipment. It does not apply to public work contracts. Going back to that second one we talked about, like I told you, only hospitals, schools, and now since August 1st, 2024, certain public safety entities can do purchasing from qualified group purchasing agencies. So when a guy from Texas calls you and says they have a great deal from a group purchasing organization, and you're not a hospital district, a school district, or one of those specific public safety entities, you cannot buy it from that organization. You need to check and see if that contract is on the state contract. Has the state of Louisiana, through the Office of State Procurement, adopted that contract? Then you can buy it off of the state contract, not from that guy in Texas. So another alternative to the public bid process is what's called a RFP, or request for proposal process, for telecommunications and video surveillance equipment and services. This is a really great alternative. You remember the little scenario we talked about? The sheriff wanted new cameras. He wanted to make sure they were compatible with the system he always has. You can go out for public bid on that, but you could also instead use this statutory method, which what this does is it has a RFP process that allows you, and you have to follow it, that's got, you know, definite rules of what you have to do, allows you to grade the proposals that come in based on a method that you make publish. And it's not just price, though. Price is one consideration. You're going to put all your specs in and exactly what you want to do, and it allows you to select the proposal that is best, most advantageous to you, rather than the lowest responsible bidder. You're selecting the most advantageous proposal that's going to really make sure you fit. It's being used a lot with electronic water meters. The Attorney General has said that it's any type of computerized equipment, really, is what telecommunications and video surveillance equipment means. Sometimes you get some contracts that are a mixed contract. So you're buying computer equipment and you're buying software. Software would not be considered a material and supplies. So you've got to look and see what the main objective thing here is that you're buying. Another one, food preparation, for example, in a prison. You're hiring a caterer, basically. You're hiring somebody to cook the food and supply the actual, you know, components to make the dishes, the actual meat, bread, etc. So is that a services contract, the cooking of the food, or is the food, material and supply, the real contract? I would say that in that case, the materials and supplies, the food is the real contract there. So, but going back to electronic equipment, so you have to look at that. So the RFP process allows you to get really the system and the compatibility that is the best suited for you, not just the lowest price. You would be establishing a rubrics of how they're going to be graded, you know, 20% price, 50% on this, you know, 5% on something else, 5% on response time, something like that. You create the grade, the rubrics that you want, and you can judge which one's the most advantageous to you. And like I said, all of these alternatives to the public bid are permissive alternatives. You can still choose to publicly bid, or you can take advantage of this alternative to the public bid law for these electronic types of equipment. Now, anytime you're dealing with electronics, I would just want to make you aware that there is a provision of law that certain parts that are made in China, Huawei, and some other things that are in the law now require that that the vendor certify through an affidavit that none of these forbidden or prohibited parts are within any of the electronics that you buy. We do have a template affidavit, vendor affidavit to sign for this on the LLA's website, but that is a requirement whenever you're dealing, whether you're doing public bid for this type of electronic equipment, or you're following the RFP process that's established here. You have to get that vendor affidavit. We do have a flow chart for the purchasing for this alternative to the public bid, the same like we have for the materials and supplies, and the same that we have for the public bid process. You can, I think it makes it very easily read and be able to follow, to notice when your notice is. It's got to be 30 days before the dates of the proposal. How the RFP, what are the requirements, how they are awarded, how you can reject the proposals, etc. So this is also something very, we hope, helpful to have with you to understand the RFP process for purchasing computers and software equipment. Now, you may also purchase off of state contract. You may hear that quite often, or purchase from the GSA. The GSA is basically the federal contract. I'm going to want to point out one thing about the GSA before we get started. You can only purchase something from the GSA directly if that item is not on the state contract, or if it is on state contract, it's lower priced on the GSA. So for whether you're going to purchase off state contract or whether you're going to purchase from the GSA, you have to go through the Office of State Procurement. There are certain steps and requirements to be able to purchase off of the state contract. We have split this up to where Patrick, when he, in module 3, talking about the Louisiana Procurement Code, Patrick will take you through step by step how to purchase off a state contract. But any local entities may use state contract. And often when someone calls me, when they're looking for something and know whether they have to go out for bid on it or not, I'll tell them, have you looked on the state contract? Is that tractor already on state contract? Because there's a million things on state contract. You can go there first always and not have to, because it is a permissive alternative to the public bid. And there's so many things that are already on state contract. Because what the state has done, what the Office of State Procurement has done, is they've already bid out on these things yearly, and they've awarded the contracts. And there is a provision in there to where if it's on state contract, you can go to your local vendor, your local, say, car dealer, and say, listen, this is the price on state contract from Jerry Lane Ford that will give me. Can you sell it to me for this exact same price, this exact same car? And if they can, there are ways that you can buy it from the local vendor and you'll still be considered buying it off the state contract. Like I said, Patrick will go through it step by step with you. But just know that if you are buying off state contract, what you want to do is make sure you have documented the state contract number and you filled out all the forms. You have to go through the Office of State Procurement, and there are certain forms that you have to fill out in order to purchase off of the state contract, whether you're buying it from the state contract vendor, the state vendor, or your local vendor. Same thing goes with the GSA. The Office of State Procurement, before you can buy something from the GSA, like I said, in addition to the requirements that that item not be on state contract, or if it is, it's cheaper on GSA, OSP has also got to certify that you're qualified, that you're actually a governmental entity in order to buy off the GSA. Now, contracts for services. I've told you in the beginning, the public bid law, which applies to all the local entities, like cities, parishes, municipalities, does not include contracts for services. So what are contracts for services? They can be professional services, such as attorney services. They can also be services such as maintenance contracts. That's when there is often a question of whether something is maintenance or whether something is renovation, which would be a public work, right? If you have to do paint for maintenance on the water tank to make sure it doesn't rot, that would be maintenance. But if you're, really doing major renovations on the building, painting a room is what I'm trying to say is different from doing an entire rehab of the building. Now, contracts for operation and maintenance of an existing municipal water and sewer system is a contract for services, according to the Attorney General. Municipal and parish trash collection, unless it's an exclusive franchise, may be negotiated rather than publicly bid. It's a services contract, unless it's an exclusive franchise. If it's going to be exclusive and there's going to be one vendor, one company that can do the trash collection, that has got to be publicly bid out. Landscaping services, ground maintenance services, those kind of things, lawn care things are a contract for services, not public works. Now, you may have some municipalities that are under home rule charter that make things stricter for them and require bidding on your services contracts. That's going to be a case-by-case basis, but they do exist out there. And like I said, even if it is services, you can always choose to bid. But if you bid, you've got to go with the lowest price. If it's for services, what we recommend is you do an RFP process. You can go request for proposals or request for qualifications. You don't want to just hire any attorney off the street, right? You want to maybe get a request for qualifications so that attorneys can send in their qualifications to you that live, within your municipality. And you can select ones that are going to have a lot of experience, maybe with government work or for whatever it is that you need this attorney to handle. An RFP process will ensure you're complying with Article 7, Section 14, but it gives you more flexibility than a bid process, because with the bid process, like I said, once you start the bid, you've got to keep that bid process the whole way through, which includes selecting the lowest bidder. The RFP allows you to consider price as one factor, but select the person who is most advantageous for you. So for contracts for services, this is a really good avenue, in my opinion, to take, is the RFP process. Because you also want to make sure you get an engineer who actually knows what he's doing, right? If you're going to build a building, or an architect, you don't want to just select somebody and they've never done this kind of work before, and you build a library and they didn't take into account the weight of the books. And so once you start putting the books in there, it starts falling apart. That actually happened at Tulane University, just as a funny side note. Now, especially when it's coming to, that is the public policy in Louisiana. Now, as you will learn in the procurement code for state agencies, it is required that certain jobs do use for architects, engineers, and landscape architects for public works projects over $1 million. And Patrick will discuss that with you. The state requires you to use an RFQ process to select somebody with experience, but it is the policy in the state, not required, that for local entities, political subdivisions of Louisiana, that when you are using architectural and engineering services for public works projects, you want to get somebody who is going to give you somebody with experience, who is qualified, that will give you a fair and reasonable price, not just going for the lowest bidder. So you want to go the best qualified, not necessarily the cheaper. So it is definitely recommended, especially with the public works projects, for architects and engineers and landscape architects to use an RFQ or an RFP process. Now, like I said, I won't go into it too much. Patrick is going to talk about it with you in the procurement process, the procurement code module, that it's required for the state agencies. Executive branch agencies in the state are required to use a specific RFQ process to select architects, engineers, and landscape architects for public works projects over $1 million. And part of that process requires the use of a board that includes the licensing boards to make the decision on the selection of those architects, engineers, and landscape architects. But keep in mind, you should be looking for the qualifications even as a local entity, not necessarily the lowest price. So again, here is the LLA's website. Go to lla.la.gov. You go to resources, legal assistance. You can find all those flow charts that I showed you today under legal FAQs. It's in alphabetical order. It's going to be public bid. We'll have the FAQ, the entire FAQ law is set out in a format that's like a question answer of what you can and can't do. But we also have public bid flow charts, and you can get a copy of those flow charts for you. And here is the contact information. You can contact me or Patrick or Jennifer Shea, the general counsel, at any time, and we'll be happy to assist you in any way that we can. Thank you.